I'm Lee Hayworth, Chief Judge of the 12th Judicial Circuit, which includes Manatee, Sarasota, and DeSoto counties. The topic of foreclosures has been in the news for several years. This presentation is intended to be an update of the most current activity occurring in the courts and in our community. My goal, and that of the other panel members, is to bring you news about the state of short sales, options to foreclose, and information that homeowners currently in mortgage default or facing mortgage default may find useful. So let me introduce you to the panel members. Seated next to me here is Ann Weintraub. Welcome, Ann.
Thank you, Judge, for having me.
Ann is a partner with the law firm of Weintraub & Band, and that's a Sarasota law firm. Her specialty is dealing with people who are outside of the litigation context that need help trying to find options to foreclosure, looking at alternatives that would hopefully save them from having to lose their homes. She's well acquainted with the issues that are important to people who are trying to desperately to stay out of the foreclosure process. Seated next to her is Nancy Cason. Ms. Cason is an attorney with the firm of Cypret, Meshad in Sarasota. She specializes more on the litigation side. She sees the defenses that need to be raised by homeowners. She sees the tactics used by the plaintiffs' law firms to try to foreclose. And she's well acquainted with those procedures that need to be followed in order for a foreclosure to be defended or properly prosecuted. Next to her is Dr. Gregory Firestone. Dr. Firestone is with the USF Collaborative. His job in our circuit is to act as the program manager for our managed mediation program. And we'll have a discussion about what managed mediation is after I've talked to the other two attorneys here. But I think it's very important to understand what it is that he does and his role in this whole process. And for that reason, his discussion will be at the end of this. So we'll start with some statistics. To put things into context, I think it's important to understand exactly how serious the mortgage foreclosure crisis is. People have heard about it, it's been in the paper. Let me review some information that I think may be helpful to understand exactly what the courts and what people in our community are up against. I've asked the clerk of Manatee County, Chip Shore, to provide me statistics for several years that show the increase over this period of time. And I want to start with 2006 and run it through 2010, and then talk about the first quarter of 2011. Now, in Manatee County, in the year 2006, we had a total foreclosure filings of 865 cases. In 2007, that jumped to 2,576 cases. In 2008, 5,045 cases. 2009, 6,487 cases. Excuse me. And in 2010, it dropped. And we'll talk about the impact of that in a few minutes too. It dropped from 6,487 in 2009 to 3,796 last year, 2010. Currently, for the first quarter of 2011, we've had a continuing drop off here. January, we had 156 filings, February, 115, and March, 135. Sarasota County has always had a higher filing rate than Manatee. Just to give you an idea, for the same period, excuse me, in 2006 in Sarasota County, we had a total of 1,114 filings. The following year, 4,100. 2008, 8,439. 2009, 8,576. And again, in 2010, we had a drop off to 4,738. And that's had an impact, and we'll talk about how that's affected court operations. In the first quarter of 2011, we've had an increase in Sarasota, a gradual increase. 142 cases in January, 162 in February, and in March, 267. So it's starting to drift upward, at least in Sarasota County. At the same time that this increase in foreclosure filings has been happening, the resources allocated to the courts to handle these type of operations has been severely cut. And one of the problems we're facing at the moment, and I'm going to outline several issues that are before us. One of them is the withdrawal of two of the large law firms from the practice of foreclosure filings. There were two law firms. You probably heard of the David Stern law firm. There's another one that's called Ben Ezra Katz on the East Coast that had handled a number of these cases, and they pulled out also about the same time. The issues they were raising and the reason they're pulling out is because the paperwork they're submitting to the courts was being questioned. There were allegations, investigations by the Attorney General, excuse me, and other activity that called into question the validity of those documents. I have here a letter that Mr. Stern sent me. This was back in January, telling me he's withdrawing from 140,000 cases in the state of Florida. He stopped practicing as of April the 1st of 2011, leaving us in our circuit with about 4 to 5,000 cases, excuse me, that he represented owners in, or rather the banks in. So that's one problem. The second problem is the legislature last year appropriated some money for judges and circuits to try to knock down the incredible backlog that we were experiencing. And our circuit got about $212,000 for 1 year. Out of that money, we hired 4 case managers and recruited 3 senior judges, retired judges, to come in and help chip away at the backlog. When we started out in July of 2010, we had approximately 25,000 backlog cases. We were able to get that down to around 17,000. We're probably a little bit below that now with this foreclosure team that we have in place. However, the legislature, given the serious drop-off in revenues for the next fiscal year, has not indicated a willingness or an ability to refund that foreclosure assistance team. So what that means is that those 4 case managers will be unemployed as of July 1 of 2011. We will not have the resources to pay senior judges to come in and further assist. And so those are issues that we're going to have to resolve in the next couple of months. So what I'd like to do is to talk about the process as it affects homeowners before they actually get into litigation. And I'll start out by asking Ms. Weintraub, and what are short sales and how successful have they been?
Okay, short sales are an alternative for the homeowner to foreclosure. They can actually happen before the foreclosure starts or actually during the foreclosure. And what it is that you list your property for fair market value with a licensed realtor who's not related to you. That realtor then looks in your neighborhood to see in the past 30 days what is sold, what is short sold, and what has been a foreclosure. They then compare those to your home, so they price it at fair market value. And that means that in most cases, because most people owe more than their homes are worth, the home will sell for a lot less than what's owed. So the bank actually likes these because they get some cash, they don't have to finish a foreclosure action, and they're also able to have the homeowner in the property so someone's taking care of it. In the end, you could have a couple of situations. The bank can completely forgive the homeowner, and the homeowner receives what we call 1099, forgiveness of debt, or the bank can approve the short sale but request a contribution, or short sales can be denied. The important thing, Judge, is for homeowners to realize everybody's different. It's important for them not to read in the newspaper or watch TV or think what happened to their neighbors will happen to them, because every bank is different. And the bank that owns the note, the investor, will dictate the circumstances that apply.
What are the reasons why it's difficult to get a short sale? What are the impediments that would normally be encountered by a homeowner, say that they've got more than one lien or mortgage on their property, or what's wrong with selling the property to your father-in-law or your cousin?
Okay, what it is first to address what we call is a short sale needs to be what we call an arm's length transaction. That means that the realtor cannot be related to the homeowner, the buyer can't be related to the realtor. I think you get what I'm trying to say. That's because they have a guideline right now at Fannie Mae and Freddie Mac and most of the investors that for some reason they do care. who the buyer is. I predict in time they won't. I think banks will be more concerned with getting these homes off their book. So it depends who the bank is. Sometimes they do not require that, but if you're dealing, for example, with a Wells Fargo, a SunTrust, Bank of America, well, most of the banks people have, they do want the arm's length transaction. I would say that in short sales, the most difficulty people have is the ability, they want to remain current, but some lenders won't let you remain current to do a short sale. And most people were raised to pay their bills. They feel like doing a short sale is the bad way out.
So the lender says stop paying your mortgage and then maybe we'll do a short sale?
Yes, sir.
Okay. Well, how about the situation where they may have more than one lien or mortgage on their property?
That's actually common. Most people have a first mortgage, then they have an equity line. Equity lines are treated for mortgages. So what we do is the lender, as part of this process, requires a full financial disclosure. So each lender will have to receive a package from the homeowner, including their financials, a letter explaining why they need to do the short sale. Unfortunately, drop in the fair market value or the fact that you lost money is not a hardship. They're looking for, illness, death, military deployment, relocation, divorce, illness of a family member. So it can be challenging. You need to have that hardship. You may have to miss a payment. Also, the second mortgage must agree to do the short sale. If they're not in agreement, then the whole thing could flop.
Will they do that? Will the second lien holder agree to reduce what's owed to them in order to get this thing approved?
Typically what happens is a lot of people have a problem because if the home goes to foreclosure, then the second lien holder can't get anything except if they sue the borrower. But in a short sale, they have what we call leverage. They've got something over you. So they can demand, because short sales are not law, they don't have to give you anything, they can demand a certain amount of their loss to participate. So in other words, if you owe maybe $100,000 on your second mortgage, they're going to be probably looking for at least $15,000 to release you and let you close. Now the first mortgage will give them some of that money, but not all of that money. So the homeowner or the buyer usually has to contribute.
I've talked to people who tell me that they're upside down and they're just going to turn the keys over to the bank and leave and give what they call a deed in lieu of foreclosure. Is that a good idea?
Bad move. We don't want homeowners doing that. First of all, if you sit and throw up your hands and do nothing, and you refuse to see an attorney or defend yourself, Florida is a recourse state. In plain English, that means that after the foreclosure sale, the bank has 5 years in its discretion to chase you for the difference between what the house sold at the foreclosure sale and everything you owe, and then they kick in their attorney's fees and costs. So for example, if you owe the bank $200,000 and your property is only worth $50,000, you're on the hook for $150,000, which is that difference, plus about another $100,000 for their attorney's fees. So what happens is they get to chase you by getting what's called a judgment against you, and they can take money out of your pay, and in some cases, they can also force the sale of unprotected assets. So for example, a homestead is not protected from the bank who made the loan on it. So that means that there's no exemption there. A lot of people, have a mistake about this.
They think because there's a homestead exemption against creditors in Florida in the Constitution that protects them from being foreclosed, but that's not the case.
Not the case, because exempted from homestead are lenders who made loans on the property, the IRS, and materialmen and labormen who haven't been paid. So you're stuck. So even if you try to leave the state of Florida, they get to enforce a judgment in the new state where you live. And if you try to leave the country under what we call the Hague Convention, which is a little bit more complex than what I want to get into, they can also force it. So really, your credit tanks also. You've got about 10 years and 400 points as to a short sale, which typically affects your credit for about 2 years. And again, everybody's different. Want to disclaim that. But it's a lot less, you don't want to drag it out. You want to get on with your life, make it a blip on the radar screen. There's nothing people did wrong. It's usually because the people that are around them have defaulted on their mortgages, affecting the fair market value. So we're all kind of victimized at the same time.
So the homeowner thinks, great, I'm going to give my deed back to the bank, and next thing they know is they're being sued for the deficiency judgment, the difference between what the value of the house is and what they owed.
Correct.
Okay.
Not pretty.
Let me ask Nancy Cason, who, as I say, deals in litigation issues. Nancy, what would you say about the government programs that are out there to help homeowners that you see in your practice that you think would be helpful for the viewers to know about?
Well, the major program that I deal with, because I do the litigation end, would be if homeowners want to retain their home. Then the most common government program, if you want to retain your home, your best option is to get a modification of your existing loan. And so the government program for the modification is called the HAMP program. And by all accounts, it's been an abysmal failure. So I don't expect that any homeowner can easily get a HAMP modification. It's a very large challenge. You go through a lot of rigmarole. There is
That's a congressional act, right? That,
yes, it's the
Obama administration passed, and it's HAMP means something, but
Home Affordable Modification Program is what it means. And the goal of the HAMP program is not targeted towards long-term sustainability. It's targeted towards affordability. And what the government deems affordable is that your mortgage payment is 31% of your monthly gross household income. So it's a very formulaic modification. What is your gross monthly household income times 31%? That is your mortgage payment. How do we get there? They back down, they put everything you owe on the back, extend the amortization. They can do it up to 40 years. They can back the interest rate down to 2 years. However, it is a 5-year step up in most HAMP modifications. So in 5 years, you'll be right back to where you started. And it doesn't address the significant problem, especially in the 12th Judicial Circuit, about underwater mortgages. So if your home is worth significantly less than you owe and you're never turning back around, then really a modification, while it may keep you in your home short term, is not going to be in most people's best financial interest long term.
While we're on the subject of government programs, and why don't you tell us what programs you encounter outside of the litigation context?
Well, I'll tell you, Nancy's right, because when people apply for these HAMP programs, we had about 4% of Americans who qualified. It's absolutely abysmal statistics. So Obama said, look, all right, fine, I acknowledge this isn't working. I'm going to make a new program. It's called HAFA. Got to remember, with the government, it's always alphabet soup. So we've got the Home Affordable Foreclosure Alternatives Program, which in plain English means that if you qualify under this program, you've got to prove, number one, you were denied a HAMP modification, what Nancy just went through. You have to prove it's your primary residence. You have to prove that your mortgage is $729,500 or less. You also have to have the sun shining in the right direction, I mean literally. And if you qualify, you will receive total forgiveness on your first mortgage, which means you're off the hook. If you have a second mortgage, the first mortgage will offer them $6,000 or 6% of its balance, and then they have to forgive you. See, a lot of second mortgages don't want to participate in this. And some banks don't even participate, so you're blown out of the water there. But be optimistic. A lot of clients have been approved, and what happens is not only do you get that forgiveness, but you get $3,000 to relocate. So it's a good deal. You get it right at the closing table, and we have had success. I'm very pleased to say Wells Fargo, Aurora, Chase, they actually have it together. Bank of America still struggle a little bit, but they kind of tend to do that, but they'll get it. I've got some approvals from them. But, you know, again, these programs just, they don't, like I say, the people that make the rules, they just don't play the game. As Nancy said, I mean, most of our clients, they need a principal balance reduction. And the way Nancy and I work together is she'll sit and defend the foreclosure, giving me the time to work out the deal, because the bank is like a tree. One side is foreclosing, the other side is helping, and even if they're helping you, the foreclosure activity continues. So it's critical to engage somebody like Nancy to delay, to give me time to work it out.
Let me ask you, Nancy, what mistakes do you see homeowners making when they come in to see you for a conference to talk about how you want to address things? What are the most common mistakes that a non-lawyer would make, thinking that they're dealing with the situation and how it makes your job perhaps more difficult?
Well, the most common mistake that I see is that the homeowner is usually, when they get served with a foreclosure complaint, that's not the first time they've tried to deal with their lender. They have tried upteen times for a modification, for a short sale, and haven't gotten anywhere. Even though they're served with the foreclosure, usually they're in the process of doing something with the bank, be it a short sale or a deed in lieu or a modification. And so they feel as if because they're currently dealing with the lender that they don't have to respond to the foreclosure complaint. Big mistake.
Kind of the head in the sand approach, huh?
Yeah, and it's really difficult because if you do not respond to that foreclosure complaint within 20 days, a default is entered against you. Now, there is a process under the Florida Rules of Civil Procedure to attempt to have the default set aside, but one, that's up to the discretion of the judge, and two, it's going to take you some attorney's fees and costs to get there, and three, it's not a guarantee. The effect of a default is that you're precluded from raising your defenses to the foreclosure, so you lose the opportunity to raise meritorious defenses that could help you defend your foreclosure case.
So if a person does not respond or file an appropriate answer in court, they're defaulted. And explain the summary judgment process, how the plaintiffs will then move forward when a party has defaulted.
That's exactly what happens. A default is entered, and what a default does is it legally operates as an admission of the allegations of the complaint. So if you default, you de facto admit everything that the plaintiff has alleged, which then would entitle them to summary judgment, assuming they otherwise prove their case, they have their affidavits in line, they comply with the 12th Judicial Circuit's administrative rules for foreclosure. But in terms of defenses, you lose the ability to raise those defenses, and that's the most significant detriment of having a default entered against you. It is the most important thing, no matter what, that you respond to that foreclosure complaint and avoid a default. Even if they respond pro se, I can go in and request to amend that. The process for amendments is that they're liberally granted. In default, we have to establish a meritorious defense, excusable neglect, and due diligence. And in some cases, I can't meet that legal standard, and so the default could stand.
You know, we hear a lot, and people read a lot about the banks not owning the notes and problems with the paperwork. But what people need to understand is that if they don't file an answer or raise those issues and they're defaulted, the paperwork could be as crummy as possible, but under the rules of procedure, that defense, to the extent it was legitimate, has gone away and disappears. And so the plaintiff is able to proceed and take title to property that had they'd been to an attorney and had a professional counsel them, could have perhaps avoided this, at least had the issue resolved. So I think one of the things that I think is very important is to encourage people not to try to do this themselves. And there are a number of attorneys in our circuit who've agreed to work these types of cases for less than the standard fee. And if they go to the 12th Judicial Circuit website, you'll find a list of attorneys with their contact information who've agreed to work with folks something less than what they normally charge as a public service and as part of their oath as an attorney to try to help folks who are unfortunately stressed financially. And that's a good way to go about doing that. So let me ask, Ann, when you start dealing with these lenders, are there some that are easier to work with than others?
Oh, Judge, you know what? I've been doing this line of work since 2006 by accident, and I will tell you that there are extremely good people at some banks. Over the years, I've definitely built relationships with people who do care. I think the issue is that sometimes you're dealing with extremely low-level, uneducated employees who just don't get it. In other words, when you submit for a short sale, the process is supposed to take about 60 days. It could be less, could be more, but 60 days is reasonable. The issues you have, though, is again, banks have too many files, they don't have enough staff, the staff sometimes are not well trained, the government programs are really hard to get through because again, the staff doesn't know the criteria. But if you're lucky enough to know, a manager, a supervisor who does care, they'll do what's called an escalation. They'll move the file forward. So every day it's a battle. I mean, I can't stress it enough how everybody's case is different. What Nancy said is so important because the more time I've got, the better off we are. So if you don't hire an attorney, it's the silliest move ever because we've had clients who've been staying in their homes, and I'm not encouraging this, but for about 5 years. And that's great because it gives me time to work out a deal. So as long as we have an offer for fair market value, a cooperative seller, a diligent lender, short sales are accomplished every day. We get approvals for them. But you've got to have the assembly of the right people. You know, you've got to have a CPA on board to tell you, are you going to have any tax consequences? You know, and a lot of people mistakenly believe, you know, I'll just file bankruptcy, just forget these lawyers, I'll just, you know what though, bankruptcy is expensive. It costs money to file bankruptcy. Secondly, if most of your debt is in the home, filing for bankruptcy most of the time doesn't make sense, because if we could do the short sale and remove all that debt, you can get back on your feet. So I think, again, it's a case-by-case basis.
Nancy, she mentioned bankruptcy. I would imagine that people come to consult with you. They certainly may be considering that as an option. What factors do you look at to, I know you may not practice bankruptcy law, but what factors do you look at to tell them that they should or should not engage in that?
Well, what I would normally do is do kind of an analysis of where they are. And Anna is completely right. If most of your debt is isolated to the one property or properties that we're working on short sales or some other resolution, then it may be in your best interest, even if you do ultimately need to file bankruptcy, to hold off. Because if we can resolve the deficiencies in the short sale or foreclosure process, then it's not necessary for you to file bankruptcy. So I think a lot of people jump the gun and file bankruptcy, and I can understand they want it to be over with. They want closure, and they think that bankruptcy is just the way to end it. And in some cases, it does end it in the homeowners' minds, because they have some sort of closure in their mind. But really, a lot of people, in fact, most people do not need to file bankruptcy, because we can adequately resolve the default in the context of the foreclosure defense, short sale, deed in lieu, to where they don't have to file bankruptcy.
And let me ask you, how long do you typically negotiate or work with them before you find that the foreclosure has to go forward and they're actually looking at litigation?
Well, to tell you the truth, Judge, what happens is there's, when people come to see me, I draw out a little chart for them. On average, depending again on who the bank is, well, we have a collections process first. So let's say you miss about 6 payments. During that collections period, you're going to get like phone calls and letters from the bank from people who are usually sitting somewhere in the Midwest in a cubicle calling you all day, telling you they're going to throw you out of your house, which we know isn't true. Once that period is over, then they tell the bank that owns the loan, look, we're not getting anywhere with Mr. and Mrs. Jones. Then at that point, that's when the bank hires what we call a foreclosure mill firm, who employs attorneys, usually, a lot of them under a supervising attorney, who slop together these foreclosure complaints all day and then serve the homeowner. At that point, they've got to engage somebody like Nancy, and then that's when the foreclosure really begins. But like Nancy said, I mean, now we have things that Greg's going to talk about, Dr. Firestone. We have ways of prolonging that. So just because you're served with foreclosure papers, the game is far from over.
Nancy, how would you project a case going? How many months would it take? Say if a client came in today and told you that he or she had just been served papers, what would you be estimating, assuming you see there's some valid defenses? I'm not talking about a case that's hopeless because there's no defenses and is appropriate for being defaulted. What would you predict would be the time frame that one would expect?
As of now, I would say at least 1 year, but in light of the news that you've just given me, which I've just unfortunately learned today that we're going to have our additional judges cut, I would expect that it's going to be a lot more than that. In the 12th Judicial Circuit, foreclosures are handled by Circuit Civil, and we have 2 Circuit Civil judges who handle all civil matters, slip and fall, breach of contract, business disputes, you name it. Circuit Civil is the forum where all of the civil cases are handled. And now that the assistance with the foreclosures is being cut, I anticipate, especially if they're going to trial, that we're going to be looking at a lot longer than that to get it through the legal system when we are litigating defenses.
Well, in our circuit, the chief judge's tenure expires after 4 years, and I'm coming up on the end of my 4th year, and as of July 1st of 2011, Judge Andy Owens will take over as chief judge, and we've had several meetings trying to address the coordination and transition, anticipating that the legislature is not going to give us these tools that we've had this year. And so we're trying to do what we can to plan contingency for mitigating this situation. We haven't quite worked out those details. We're taping this basically in the middle of April. The legislature is over, I think, May 6th, and then we'll have some time to see exactly how much money we did get and how we can best allocate our resources to make things work. But I'm not terribly optimistic that we'll be able to improve what you're saying, and it may very well be, regrettably, a serious impact on the business community, and we don't know quite yet how it's going to shake out, but we're going to do our best with what they give us.
Can I interject one thing?
Sure.
I mean, I'd like to say this, that I'm personally shocked that in the state of Florida, I would consider this an unemployment, issue 1 and issue 2. Surprises me of the lack of understanding, by both the governor and the legislature, and we're not making this political, but these are issues that must be dealt with. These are critical issues. And you've taken the lead as a judge to go ahead and be proactive and go above and beyond your role and make people talk to their banks. You saw that a couple of years ago. You know what's needed, and all the judges are in agreement with you. The community's in agreement. We have to do something. I think, I always tell people, I say, talk to your elected officials, talk to your state representatives. Do something, because I think people can, in groups, if they realize this is such an issue, help us out here.
Well, the courts have always been focused on trying to avoid backlogs and trying to see that cases progress through the court system as efficiently as possible. And I think we've done a pretty good job with that over the years, but we can only do so much with the tools that they give us. And I know for a homeowner who's facing foreclosure, the fact that the foreclosure is going to be delayed for several more months may be good news. But then you start thinking about the homeowners associations and the condominium associations and the people who live in those communities where the homeowners or the condos are not able to get their assessments to fix the common areas and to do the things that need to be done. And that's also an issue, and so we're sensitive to that, and we want to move cases. Do you have condominium associations, Nancy, that are complaining about not getting their case resolved?
Absolutely. I think that's one of the most significant issues, is that condominium and homeowners associations, depending on which one it is, can either go back either a year or 6 months. So if a foreclosure takes I've got some going on 3+ years, if that lender takes title at the foreclosure sale, they're only responsible for 6 months to a year back. So the homeowners association loses out. When the homeowners association or condominium association, whichever one it is, loses out, they have the ability to then assess the other paying owners for the deficiency to cover the operating expenses. So what I'm seeing now is that homeowners associations, condominium associations are filing motions with the court to move the cases forward, and the courts are agreeing to move the cases forward for them, but a lot of the times in the end, the plaintiff's attorneys just don't have their act together, and they wind up dismissing the case, which is a breath of fresh air for the homeowner who's got a little bit of reprieve, but for the association, it's not good news.
The problem that not just the 12th Circuit is facing, but it's a statewide problem in our courts, is that without the funding to hire the people to do these case managements and the things that our senior judges are doing, there's going to be an inevitable backlog and delay. And we've made the argument to the legislature that the courts really should be an engine of economic recovery. And we think funding, particularly in this area where we are so inundated with a huge number of cases, that it makes economic sense to do it. But they've got a lot of issues up there, and they got people with disabilities not getting money, and they got the Medicaid problem, education, and all that. So we're trying to make our case heard, and hopefully it'll resonate. So far we haven't got much traction, but a lot of people are in the same situation.
And Judge, one of the other things that I think is important to mention is you just mentioned a figure of 17,000 cases that I think are backlogged in the system. I also refer to that as shadow inventory, meaning that those are loans that are in default. Hopefully most of them will resolve via short sale or deed in lieu of foreclosure, but I would suspect that a vast majority of those 17,000 cases are just houses waiting to come on the market. Yep. So I don't see see there being any real meaningful recovery in our judicial circuit until we chew through these foreclosures, because as Ann knows, as I know, once a bank takes it at foreclosure, they put it on the market and they essentially fire sale it because they don't want to have to pay, continue to pay taxes, insurance, maintenance. So they are just looking to get rid of it, which then drives down the prices of people trying to just sell their houses normally. So until that shadow inventory is chew through the shadow inventory, there's not going to be a real meaningful recovery because you got 17,000 extra houses coming on the market in the next 6 months to a year.
Well, the practical problem from our standpoint is you've only got so much time during the day to hear cases. And without having the resources of currently 3 senior judges coming in 2 or 3 times a week, stretched out over however many months, and having the logistical help to help process the paper. You know, my analogy is that we have all the pilots we need. We got judges that we can send in and do the work for the hearings. What we don't have is a ground crew. And the plane can't take off and function properly without having the ground crew. And that's where we're getting shorted. So we'll see how it develops. Hopefully we can work some things that'll make it less serious. But let me jump forward towards the end of the case, Nancy. Let's say there's been a summary judgment entered. What does that mean, and how does it go from that point to changing to ownership to the plaintiff or the lender?
Okay, so hopefully the homeowner has raised defenses to the foreclosure. And if those defenses are found to be not applicable or the court has denied those defenses, then what will happen is a summary judgment will be entered as to the foreclosure. The court will enter a final summary judgment, and then the sale date is set. By statute, it's supposed to be about 30 days from the date of the entry of the judgment, but they can stipulate to a longer period of time. And I am seeing, that's the one concession I'm seeing lenders routinely give, is that instead of a 30-day sale date, they'll allow 60 to 90 and sometimes up to 120 days. Once the sale occurs, the certificate of title is issued within 10 days of the date of that sale. By that time, the homeowner needs to have vacated the property, or else the lender can come in and get what's called a writ of possession and have them displaced.
Well, I think the thing too that's interesting here is that for centuries, actually we inherited this process from the English. When a property was sold, it was done on the courthouse steps by a process called public outcry. And very recently, the clerks in Manatee and Sarasota County have come into the 21st century, and now we do it online, kind of like a eBay situation. So people don't go to the courthouse anymore. It used to be a big crowd around the clerks. You'd read through the legal description. It would take, you know, an hour or two to go through all the list of foreclosures. Well, now it's done very efficiently online, and people can do it that way. How about renters? What do they need to worry about if they're renting from somebody that is being foreclosed, their owner is being foreclosed? What rights protect them?
There is a national federal act that protects tenants, and basically it has to deal with whether your lease was entered into before or after the commencement of the foreclosure. If it was before, then they do have to honor your lease so long as it's a fair market, arm's length lease, and you're paying your rent. If not, then there's about a 90-day window from when the final judgment of foreclosure and certificate of title is entered to where they would have to give a tenant in possession notice before they can displace that tenant.
Okay, and I think it's important for tenants to know if you're leasing property, you do have rights, and you can consult with an attorney if you get a notice that your owner is being foreclosed, and you should be served papers. You're supposed to be served because you have an interest in that property as a possessor of it. Well, let me transition now to the subject of managed mediation. Dr. Firestone is the director of the Conflict Resolution Center at University of South Florida. Professor, let's talk about how managed mediation works in the 12th Circuit. Give us kind of an outline of how that works.
Well, at the time that the foreclosure filing is submitted to the court, it's also submitted to USF and our partner organization, the Collins Center. And the borrower is contacted, and sometimes that's hard to do because there may not be the correct information. So maybe I say many attempts are made to contact the borrower, and it's important for borrowers to know that if they hear from the Collins Center for Public Policy or they have reason to have contact with USF, that we're the court-authorized, court-sanctioned program. I know many borrowers are getting deluged with other calls, people promising them all sorts of things if they'll write a check or they'll turn over their house or something else. But if they hear from the Collins Center, and the Collins Center is the one reaching out to them, they can agree to participate in mediation. And if they do that, it gives them the opportunity to sit down with a lender. And as you all know, one of the biggest problems that borrowers have is they can't find anyone to talk to. That's what you often hear. And in fairness, you hear that sometimes from the lenders and services as well, that they're having a hard time finding the borrower. So mediation's a time to be in the same room and talk. So if borrowers agree to go to mediation, they're then asked and referred by the Collins Center to a foreclosure counselor who will assist them in organizing their finances, collecting whatever documents that they need to provide. Those documents and financial disclosure are provided to the Collins Center, and the documents are forwarded on to the lender or the servicer. And after the lender servicer have it, within or after 30 days, a mediation can be scheduled. And so here's an opportunity to sit down and have that face-to-face discussion. And if the borrower wants to talk, you mentioned short sales and loan modifications and deed in lieu or anything else, they can let the plaintiff know what they'd like to talk about. And there's some other information they can provide to let them know that the house is on the market. And that sort of thing.
And this process is something that was approved by the Florida Supreme Court and adopted, the Supreme Court, adopted what they call a model administrative order. Dr. Firestone and myself were on the task force with the Supreme Court's appointment to help work through this. And one of the significant things about it is how the money happens. Is it going to cost the homeowner any money?
Well, likely no. The servicer or the lender comes in and has to pay the upfront cost to start the program, and that's a $400 payment they make, and that covers the outreach to the borrower, the foreclosure counseling, and everything up to the mediation. And then at the time that the mediation is scheduled, the plaintiff, again, the lender or the servicer, would be paying $350 for that mediation to occur. And it would only be if later the lender were to go to court and try and collect on payments that, or debt that the borrower had on the mortgage, attorney's fees, and some of the things that were being discussed earlier by both of you, really. Then it's possible that the borrower could find that they could be responsible for that $750. But if they work out a settlement, in that settlement, if there is a waiver of a deficiency judgment, then they wouldn't be responsible for any of that. So it's possible, but I'd say not likely.
Well, I think we need to emphasize, too, that the managed mediation program that is approved in our circuit and across the state applies to homestead owners.
Exactly.
In other words, if you're an owner of a rental home or a second home, it's not your homestead. And what's a homestead? Well, we look at the tax rolls of the tax assessor, and if you're okay with the tax assessor as being homestead, you're okay with us. And so what happens is that a homeowner, when the package of papers served upon them by the sheriff or a process server is received, in that stack of materials is a notice, and it states very clearly that you have the right as a homeowner, homestead owner, to participate in this program at your request, and that there will be no out-of-pocket expense. As Dr. Firestone points out, at the end of the case, if it's not successful, the $750 may be tacked on to the other $300,000 or $400,000 that you may owe and made part of the judgment. But as far as out-of-pocket expenses, there are none. And as he points out, the key really is getting people to respond to this. I think the Collins Center, which has a call center, people get on the phone, they do Google, they do everything they can to try to find people, but a lot of people shut down, I think, when they get notice of that. Y'all probably seen that in your practice, haven't you?
I think people are just tired of phone calls and being bothered, so they just stop answering their phones, so you don't even know who's good and who's not. So I think, a lot of the success of the program is going to depend on people watching programs like this and listening to Dr. Firestone to be given that heads up to know if it is the Collins Center, call them back.
Right. Well, one of the things that we require the lenders to do is, first off, we require them to identify the homesteads. Secondly, we require them to notify the Collins Center, which is working in partnership with the USF Collaborative, that there is a case that's eligible for mediation. And then it goes forward from there with the Collins Center coordinating now with the homeowner to try to get them into their counselors. Who are these people that are doing the credit counseling?
That's being handled locally now by Gulf Coast Legal Services, and it's really nice because people have an office to go to, a person they can meet, and we're hearing very positive results from borrowers from the Collins Center and from Gulf Coast. It sounds like it's been working, and it's only a recent change that you authorized. I did want to add one thing, and that is that the program's not limited to homestead. If there are other homeowners who would like to participate, they can request to participate in this program. The difference is if it's a homesteaded property, and the other thing is if it's a commercial loan, if it falls under the Truth in Lending Act, then the lender can't proceed, or the servicer can't proceed to foreclose if directly without going to mediation first if the borrower wants to. But in those other cases where it's not a homesteaded property, the borrower could request it, and while the lender or servicer is not obligated to participate, I suspect many would see that it might be in their best interest to do so. At least I would hope so, because I think this is a chance to sit down again, work things out. And with the foreclosure counseling up front, it's a big help to the lenders and servicers, because what it means is when they sit down with the borrower, they've got all the information they need, and they can make a quick decision on what to do.
Yeah, I think a lot of people have a lot of apathy towards this whole situation. They get so angry because of what's going on that, and they should be angry, because I think with the home, it's kind of like a grief process to where you finally one day come to an acceptance. But until then, a lot of people, they think they're doing the right thing by being angry and not calling anyone. Well, this is one of those situations in life where you just need to bite the bullet and do it. You've got to be out there helping yourself.
Right.
And I think today what we've talked about, it's easy to obtain free counsel, free credit counseling, free mediation, to where it leaves someone with actually no excuse not to do something. You've got to do something. I mean, if you want results of any kind in life, you can't just sit there. And I think, if the viewers are watching, that's something that they should really be aware of, is to get past that anger and get somebody involved so you don't have to talk directly with the bank, and that will be a much less emotional process, because everybody just wants to get this over with.
Well, and I think that's a good point, and I think in mediation that's really important, because the mediator is not a decision maker in this process, and so it really takes the borrower, perhaps with representation, coming in and assertively and positively talking about proposals to resolve this situation. Ignoring the problem, as Judge, you were pointing out, means you may lose some of the defenses you have in the case, and you may really fail to achieve an outcome that might have been far more positive. And many people think the mediator makes the decision. The mediator really just structures the conversation. And the other nice thing about mediation is it's confidential. Now, there are some exceptions, but by and large, it means here's a chance to talk openly and freely and try and work out a resolution. And the only thing that goes to the judge at the end of mediation is, was there an agreement or not? And if agreement is worked out, basically, am I right, Judge? Case closed, and
we're very happy to see that.
And I'm sure you are very happy to see that.
17,000 less one.
And
not seeing as many of those as we'd like, but
and if there is no agreement, then that's all the judge is hearing, no agreement. So there's not a lot at risk in terms of speaking freely in mediation. Of course, there are, as I said before, there are some exceptions, but by and large, the beauty of mediation is you have somebody running the meeting. So if somebody maybe feels they're not assertive, and maybe they don't have help, at least here somebody's going to help make them comfortable and give them a voice in mediation.
Where do you get mediators?
Well, all our mediators are certified by the Florida Supreme Court as circuit civil mediators, or what the court calls circuit court mediators. And in addition to that, they've had special training in residential mortgage foreclosure mediation. So these are really top-notch people with the right training, and their goal really is to help people reach an agreement. They don't come in with a preset idea that there should be a deed in lieu, or there should be a short sale or a loan modification. They just come in with an idea that they want to help people talk, and whatever the borrower and the lender or servicer, the plaintiff, wants to work out, that's fine with the mediator.
And Judge, something that I would like to add to that is it is only applicable to homestead foreclosures, but there's a provision in our administrative order locally that says, yes, it's only available automatically to homestead, but you have the right to apply for mediation. And in Florida, under Florida statutes, there's a mediation statute, and essentially there are certain things that are exempt, but foreclosures are not, so you can always apply for mediation.
How would they do that?
They would have to file a motion to compel mediation and set that for hearing either in front of a judge or or in Sarasota, the magistrate. And I've found that I've been very successful in either homestead cases filed before the effective date of the administrative order or non-homestead secondary residence cases. People are still facing the same issues, and so you can apply to the court to be authorized to participate in the program. The only slight downstroke I'm seeing is that if it's not a case that's automatically subject to mediation, you may be compelled to pay half of the mediation fee, so $350. But you still have the opportunity to request that the court order mediation in your case, so you're not deprived.
Yeah. And one of the positive things about that is when you're in mediation, the lender or servicer is required to send somebody to mediation who has authority to make a decision there on the spot and settle the case.
Do they show up in person, or how does that work?
Well, now there is an exception for the residential mortgage foreclosure where they could be on a telephone, but they have to have somebody in the room who can sign and bind the lender or the servicer, and they have to have an attorney. Now, it could be the same person, and typically is, or it could be two different people. But the beauty is many times borrowers find themselves talking to somebody who doesn't have the authority to make a decision. And so here in mediation, you have somebody who has authority to make a decision. If the lender or servicer doesn't show up with that authority, they haven't complied with the court order, and likely another mediation would be set. So they could work that out, and unless the borrower waived and was willing to talk to somebody who didn't have full authority.
And what has been your experience with these, Dr. Firestone, as far as success rates, just generally speaking? Have you found that there's a lot of progress being made there, or are the servicers still kind of hunkered down and not willing to come forward with real solutions? We're
not where we should be, from my perspective. We're seeing a settlement rate a little below 30%, maybe 29%, 29 point something percent. And in most other court mediation programs really around the country, if you look at the statistics, you're seeing anywhere from 60 to 90% settlement rates. And by settlement rate, I mean they leave with some kind of agreement in writing to resolve all or at least some of the issues at hand. And in this area, as I said, maybe we're half of where we should be. Now, you made some very positive changes, I believe, a few months ago that will require that the plaintiff will have certain documents in their possession 30 days in advance of mediation, which unfortunately wasn't always happening before that. And I'm optimistic that now that those cases are finally sort of coming to mediation, because as I mentioned earlier, it can take 60 to 90 days from when a filing happens to when the mediation occurs, or maybe even 120 days. So we're just beginning to see those. But I'm hopeful that in the next few months, with that very positive change, that we're going to see a higher rate. And then, as Ann, I think, as you both were saying, there are some banks and some lenders that really come in and want to work with the borrower and are eager to find an agreement and move on. And then there are others that, for whatever reason, and it's always hard to understand what those reasons are, aren't as eager and motivated to try and work something out with the borrower as quickly and effectively as I think is possible.
Well, the homeowners don't, I guess, need an attorney to go to mediation, but does that kind of put the mediator in a bad position or a difficult position when the mediator knows that there's something there that needs to be discussed? How does a mediator do that when they have a non-lawyer homeowner at the table, and on the phone you've got the servicer and maybe the plaintiff's attorney sitting there, the opposing party's lawyer, in the room to get...
Well, that's a good question. First, let me say that if the borrower has an attorney, the attorney has to come to mediation as well, and that's a requirement of the administrative order that was referred to earlier. But if the borrower doesn't have an attorney and doesn't understand really what's going on, the mediator has an obligation by rule of court. In the rules for certified and court-appointed mediators, it says that a mediator shall advise the parties of their right to counsel, that they have a right to have an attorney. Well, that's not helping somebody a lot if they don't understand what's going on. Mediators differ in terms of how they might address that. The mediator could ask the attorney for the plaintiff to provide some information. The attorney for the plaintiff obviously can't give legal advice to the party, but the mediator could ask some questions in terms of how long does it take for this or how long does it take for that, and that sort of thing. And I think mediators vary in terms of that. Mediators are allowed to give some information, but they can't cross the line and give legal advice.
Where is the mediation held? Where would a person go for that?
Our office is centrally located in the 12th Judicial Circuit. We're in the Lakewood Ranch area. We're just off University Parkway on Lakewood Ranch Boulevard. The address is 5804 Lakewood Ranch Boulevard. So it's pretty easy to get to from anywhere in the 12th Judicial Circuit.
Well, let me also point out that there's some great resources for folks. In addition to the website, METV, and the 12th Judicial Circuit website, which all you have to do is go online and put in your search for the 12th Judicial Circuit of Florida, you will find our website with a wealth of information about foreclosures. In addition, Manatee County and Sarasota County both have been very assertive in trying to help people out in this situation. Sarasota County, for example, has something called the Foreclosure Resource Assistance Network, sometimes called FRANNY, and if you go to scgov.net, you will find presentations such as this and a great deal of information that will help people going through this process. Well, we're coming pretty much to the end of this. We're running out of time, so I want to give each of you an opportunity to make some closing remarks. Anything that you think that you want to reiterate or emphasize for the viewers here tonight and today? I'll let you start there, Ann.
I would say don't freeze. A lot of times people just freeze because this is so overwhelming. They don't do anything. Even though they want to, they have a lot of anxiety. Try to calm down and take baby steps. Take each day as it comes. A lot of people also don't even like lawyers, okay? So
don't be afraid of the lawyer.
Don't be afraid of the lawyer. We're not going to bite you.
Well, some of them might,
yeah, maybe. Yeah, no kidding. So, but pick someone you're comfortable with, because you know what? This is a personal decision. We all are human beings. We understand there's a lot going on. A lot of my clients are sick. Some of them have lost everything. So we do empathize, and we treat this, holistically. We see the whole picture of life. And again, our objective is to move you on, not have you linger in our office. So I encourage people to not freeze and to take action.
Nancy.
From a litigation perspective, you must respond to that foreclosure complaint within 20 days of when you're served. You need to file your relevant affirmative defenses. You need to look at the plaintiff, look at the documents attached to that complaint. Does the person have standing? Do you have any defenses that you need to raise? And then you need to raise them. And then throughout the foreclosure proceedings, you need to ensure that all of the documents submitted by the plaintiff in support of their claim are 1, true and correct, 2, appropriate under the rules of civil procedure. And you want to make sure that there's this big scandal about fraudulent documents, robo-signed documents. You want to make sure that your documents are proper in the case.
And make sure if you represent yourself that you raise legitimate issues.
Yes.
We require that of the plaintiffs and the defendants. We don't want to see people just boilerplating in defenses because it's supposed to be something that has a factual basis and a legal basis, not just something you pull off the internet and Xerox and put in the file.
Absolutely.
Okay. Dr. Firestone.
First, let me say that our office staff are bilingual, and we have mediators that speak a variety of different languages, so no one should let language be a problem for them, or even sign language for mediation. Second, we too have a website, and it's mediate.crc.usf.edu, and you can learn a lot about the program, and you can also link to the administrative orders that we were talking about, as well as to the Collins Center. And then lastly, I'd just say, if you're a borrower and you're not hearing from the Collins Center when you've gotten a notice of foreclosure, you need to contact the Collins Center and say, here I am, I'd like to participate in the program, because it may be through no fault of the borrower that the Collins Center can't find this person because the incorrect information was provided in the Form A that is given to the Collins Center. So it's important to say, here I am, I want to participate and get involved.
Well, thank all the panel members for their help here today. I hope what we've talked about today will be of assistance to folks facing this dilemma. We want to thank METV for giving us the time to make this presentation, and I hope that your future is bright and that there will be fewer cases filed next year than there were last year. With that, we'll sign off. Thank you.